The lake had always been the reason I bought the property, not because it was flashy or oversized, but because it was quiet, self-contained, and clearly mine, a natural stretch of water that sat fully within the boundaries of the land I owned, recorded, surveyed, and taxed without ambiguity. And for years it existed without drama, a place where mornings passed slowly under open daylight and evenings settled into stillness without interruption, the kind of peace you don't question once you've earned it. The surrounding area had grown over time, houses appearing farther down the road, a homeowner association forming where none had existed before, but my property stood apart, both physically and legally, a fact that had been made clear during purchase, inspections, and every official document that followed, and because of that, I never imagined the lake would become a point of conflict. That illusion ended the morning I noticed unfamiliar footprints near the shoreline, not careless ones but deliberate, the kind left by people who believed they had permission. And when I followed them back toward the access path, I found a small sign staked into the ground, clean and newly placed, bearing the logo of the Homeowner Association and the words Community Lake Access, as if saying it confidently enough could make it true. I stood there reading it again and again, letting the meaning sink in because it wasn't a request or a suggestion, it was a claim, a statement that rewrote ownership with a few printed words, and before I could even decide how to respond, voices carried across the water, unfamiliar men laughing, casting lines into the lake like they'd been doing it for years. I approached calmly and asked who told them they could be there, and one of them answered without hesitation that the HOA had informed residents the lake was community property, open for use. And the certainty in his voice was what made my jaw tighten, because confidence like that doesn't come from misunderstanding, it comes from authority being handed down, even if it's false. I told them the lake was private, that it sat entirely on my land, and that they needed to leave, and while a few looked surprised, others looked irritated, as if I were the one disrupting something they'd already been promised. And one of them said the HOA had maps proving it belonged to everyone, a sentence that told me this wasn't an isolated mistake, it was a coordinated lie. By the time they packed up and left, muttering about reporting me, I already knew this wasn't going to end quietly. Because once an HOA tells people something is theirs, it rarely walks that back voluntarily. Later that same day, under the same bright daylight, the HOA president showed up without calling ahead, standing near the lake's edge like he was inspecting an asset, not trespassing. And before I could even speak, he launched into an explanation about shared community resources, claiming the lake had always been intended for collective use and that recent reviews had clarified its status, a statement that would have been laughable if it hadn't been delivered so seriously. I asked him to show me the document that transferred ownership, the easement, the agreement, anything recorded, and he waved it off, saying the association's internal records were sufficient, that the developer had intended shared use. And that intent mattered more than technicalities, which was the moment I realized how dangerous the situation was. Because men who dismiss deeds as technicalities are willing to take whatever they think they can get away with. I told him plainly that the lake was private property, that no easement existed, and that the association had no authority over it. And instead of backing down, he accused me of trying to deny the community something it was entitled to, framing me as selfish, unreasonable, and obstructive, a familiar tactic when facts don't cooperate. Neighbors began to gather along the road, drawn by the raised voices, and the HOA president leaned into the attention, speaking louder, explaining that the association would be formalizing access, installing signage, and scheduling maintenance. And when I told him no one was authorized to enter my land, he smiled and said the HOA had already approved it, as if approval alone could override ownership. That was when the anger settled in fully, not hot and reckless but focused. Because I understood exactly what was happening, the HOA had seen a lake, seen value, and decided to claim it by narrative rather than law, assuming I'd either fold under pressure or lack the resources to push back. He warned me that denying access could lead to fines, enforcement actions, and further escalation, and he said it like a favor, like he was offering me a chance to comply before things got unpleasant. And when I asked again for a recorded document supporting his claim, he said it would be provided in due course, a phrase that means nothing but buys time. After he left, the sign remained by the water, an object that shouldn't have been there but now existed as a symbol of intent. And I took photos, not out of paranoia but preparation, because I knew from experience that once an HOA plants a flag, it treats silence as consent. That evening, I reviewed my closing documents again. The survey clearly showing the lake entirely within my boundaries, no shared lines, no access corridors, no easements of any kind, and I compared them to county records, confirming what I already knew, that the HOA's claim wasn't just wrong, it was fabricated. Still, the next morning, more people appeared, casting lines, walking dogs near the water, acting like the lake had always been communal. And when I asked them to leave, one of them said the HOA told them I couldn't stop them, that the lake belonged to everyone now, and that word now stuck with me, because it implied a change that had never legally occurred. By midday, another sign appeared, this one larger, more official-looking, declaring the area a community amenity, and that was the moment I understood the full scope of the lie. Because the HOA wasn't testing the waters, it was moving fast, establishing presence, building expectation, and creating a conflict where hesitation would work in their favor. I removed the sign, carefully documented everything, and when the HOA president returned later, furious, accusing me of destroying community property, I told him clearly that anything placed on my land without permission was trespass, and his response was to threaten enforcement, claiming the association would involve authorities if necessary. That threat didn't scare me, but it clarified everything, because if the HOA was willing to escalate a lie into official action, then this wasn't about fishing or access, it was about power, about whether an organization could redefine ownership by repetition and pressure. As the sun moved across the lake and the day wore on, I sat at the edge of the water looking out over something I'd believed was settled long ago, realizing that the peace I'd taken for granted was about to be tested, because the HOA had made its move publicly and confidently, and it had done so under the assumption that I wouldn't know where the real boundaries were. They were wrong about that, but at that moment, standing there with the lake quiet again and the road buzzing with rumor, one thing was certain: the conflict was only beginning, and the lie they'd chosen to build their claim on was about to cost them far more than they understood. The escalation came fast and loud. Like the homeowner association realized that claiming the lake with signs and rumors wasn't enough and decided pressure would do what lies alone couldn't. Because within 24 hours the shoreline that had always been quiet started filling with people who acted like they'd been invited, coolers set down, fishing lines cast, boots trampling grass they'd never touched before, and every single one of them said the same thing when I told them to leave. That the HOA said the lake was community property and that I didn't have the right to stop them. By midday, the access path that led toward my land had a temporary rope barrier installed by the HOA, not to block entry but to funnel it, like an entrance gate to something they already believed they owned. And when I removed it, another appeared by evening along with a new notice taped to a post claiming shared amenity access hours. Language so bold it was almost impressive in its audacity. The HOA president returned that afternoon with two board members not to talk, but to assert, explaining loudly that residents were upset that complaints were coming in, and that my refusal to allow access was being documented as obstruction of community resources. And when I asked again for the recorded easement or ownership transfer that gave them any claim at all, he accused me of being uncooperative and hostile, reframing my insistence on proof as bad behavior. Neighbors began gathering along the road, some confused, some irritated, because the HOA had clearly told them one story while reality showed another. And instead of clarifying, the president leaned into it, announcing that the association would begin formal management of the lake, including maintenance, scheduling, and enforcement, and he said it like it was already decided, like my consent was irrelevant. He warned that denying access could lead to fines, penalties, and legal action, repeating the same threats in different words, hoping repetition would make them stick. And when I pointed out that the HOA had no jurisdiction over my land, he claimed the developer's intent overrode individual ownership, a statement that made several men in the crowd exchange looks because intent doesn't override recorded law. The escalation took another turn when an email went out to the entire community that evening, announcing the lake as an official HOA amenity, inviting residents to enjoy it responsibly, and making no mention of private ownership at all, effectively rewriting reality in one broadcast message. And by the next morning, people arrived in groups, confident now, emboldened by the association's endorsement. I confronted the HOA president again, told him the email was false, that the claim was untrue, and that he was misrepresenting property ownership, and instead of backing down, he accused me of trying to intimidate residents, flipping the narrative completely, and warned that continued interference could result in authorities being contacted to maintain peace, a thinly veiled threat designed to make me hesitate. Signs multiplied along the shoreline, trash bins appeared as if to establish permanence, and a maintenance crew showed up briefly to assess the area, stopping only when I told them they were trespassing. And when they left, the president accused me of disrupting authorized work, documenting it as another violation. What made the escalation dangerous wasn't the noise or the crowd. It was the speed, because the HOA wasn't waiting for permission or proof. It was creating facts on the ground, building usage patterns, encouraging reliance, and positioning me as the obstacle. Knowing that once enough people believed the lake belonged to them, reversing that belief would feel unfair even if it was wrong. Neighbors started approaching me directly now, some angry, some confused, asking why I was taking away something they'd been told was theirs. And I explained calmly every time that the lake was private, that no easement existed, that the HOA was lying. But explanations struggle against authority when authority speaks louder and more often. The president seized on that tension, telling anyone who would listen that I was exaggerating ownership, that the documents were unclear, and that the association's legal team was reviewing the matter. Another claim unsupported by anything written, but delivered confidently enough to sound real. By the end of the second day, the HOA had effectively turned my lake into a test case, daring me to escalate while pretending they were simply responding to community demand. And when I removed yet another sign, the president showed up furious, accusing me of destroying HOA property and warning that continued actions would force him to call authorities to resolve the dispute. That was the moment the escalation crossed a line, because involving outside enforcement based on a false claim isn't a misunderstanding, it's a calculated move, and standing there under full daylight with men watching from the road and the water no longer quiet, I realized the HOA wasn't going to stop unless something forced it to. I went back inside, gathered every document again, deed, survey, tax records, aerial maps, historical filings, and laid them out in order. Because at this point the conflict wasn't about fishing or access or neighborly tension, it was about an organization knowingly asserting ownership it didn't have and daring me to challenge it publicly. As the sun lowered over the lake and the shoreline finally cleared, I knew the HOA believed it had momentum, that by escalating fast enough it could overwhelm facts with volume. But what it didn't understand was that every sign, every email, every threat, and every unauthorized person it encouraged onto my land was building a record. And once that record reached the right eyes, the lie they'd chosen to stand on wouldn't just collapse quietly, it would bring consequences with it. Consequences far beyond a neighborhood argument, and that understanding shifted everything. Because the escalation they thought was cornering me was actually pushing them straight toward a reckoning they weren't prepared to face. The crisis exploded the moment the Homeowner Association decided to turn their lie into an official incident. Because late that morning, under harsh, unmistakable daylight, I watched two patrol vehicles roll slowly down the access road toward my lake, lights off but presence deliberate. And before either door opened, I already knew exactly who had made the call and why. The HOA president stepped out of his car almost immediately after them, posture stiff, expression confident, acting less like someone reporting a dispute and more like someone expecting validation. And when the officers approached, he began speaking before they even asked a question, explaining that I was blocking residents from a community lake, that tempers were flaring, and that he feared the situation could escalate if I continued to interfere. I waited until he finished, because when someone builds a case on confidence instead of facts, interruption only helps them. And when the officers finally turned to me, I handed them my deed, my survey, and the tax map showing the lake entirely within my property boundaries. Documents I had already laid out that morning because I knew this was coming. The shift was immediate, subtle, but unmistakable, because the officers stopped looking at the lake and started looking at the HOA president, asking where the easement was, where the recorded agreement was, where the document existed that transferred ownership or granted access, and his answers unraveled in real time. He talked about developer intent, internal HOA maps, community expectations, and long-standing use, none of which meant anything in the face of recorded ownership. And when one officer pointed out that intent and expectation don't override a deed, the president's tone sharpened, insisting the HOA had authority to manage shared resources, even if they crossed private lines, a statement so reckless it drew a pause from everyone present. Neighbors gathered quickly, drawn by the sight of police vehicles near the lake, and the crisis deepened as the crowd grew, because now the lie wasn't just being told to residents, it was being told to law enforcement in full daylight. One of the officers walked the shoreline, confirming the survey markers, comparing them to the documents, while the other asked the president directly whether he had informed residents the lake was private or community-owned. And when he answered that it was community property, the officer asked how the HOA came to own it, a question met with silence long enough to be noticed by everyone watching. That silence was the moment the narrative cracked, because without paperwork, authority collapses fast, and the president tried to recover by accusing me of provoking conflict, claiming I was threatening residents by asserting ownership, and suggesting that my behavior warranted intervention, but the attempt backfired, because asserting a legal right isn't a threat, and the officers knew it. The crisis escalated further when several residents spoke up, contradicting each other openly, some saying they'd been told the lake was private until recently, others admitting the HOA had announced it as a new amenity without explanation. And that inconsistency mattered because it showed the claim wasn't long-standing, it was invented. The officers asked the HOA president if he had placed the signs, sent the emails, and encouraged residents to enter the property. And when he confirmed it, the officer told him plainly that encouraging entry onto private land without permission could constitute trespass, regardless of HOA position, and the color drained from his face as the weight of that statement landed. Still, he pushed, insisting the HOA would pursue legal action, claiming they had lawyers reviewing the matter, and demanding the officers remove residents who supported me from the area, a request that was immediately denied because law enforcement doesn't enforce HOA narratives. The crisis reached its most dangerous point when the president accused me directly of harassing residents and demanded I be removed from the shoreline. And one officer turned to him and said calmly that based on the documents presented, I was the landowner and had every right to be there. And that statement hit the crowd like a shockwave, because it was the first time authority had contradicted the HOA publicly. Murmurs spread fast, confusion turning into realization because many residents suddenly understood they'd been misled. And that realization brought anger not toward me, but toward the man who had promised them something he didn't own. The officers instructed everyone to leave the shoreline immediately, clarifying that the lake was private property pending any court order stating otherwise. And when the HOA president objected loudly, claiming the HOA would not recognize that determination, the officer responded that recognition wasn't optional, that property law isn't subject to HOA approval, and that any further attempts to assert control without proof could result in consequences. Phones were recording openly now, capturing the exchange, the correction, the visible collapse of confidence, and the president noticed, his posture shifting from aggressive to defensive as he realized the situation had slipped beyond his control. When the officers left, the shoreline cleared quickly, the signs were ordered removed, and the temporary calm that followed felt heavy, not resolved, because crises don't end when people walk away, they end when accountability arrives, and this one was just beginning. The HOA president lingered, furious, accusing me of humiliating him, claiming the community would remember this, and warning that legal action would follow, but the threats sounded hollow now, because they'd been exposed in front of witnesses who would never forget what they saw. That afternoon, emails went out from the HOA office attempting damage control, reframing the incident as a misunderstanding, urging residents to remain calm, and stating the lake's status was under review. A sharp retreat from the confidence they'd shown days earlier, and that retreat mattered, because it acknowledged uncertainty where certainty had been falsely asserted. I documented everything again, the police presence, the statements made, the admissions, the retractions, because this wasn't just a neighborhood dispute anymore. It was a record of an organization knowingly misrepresenting ownership and escalating a lie into a public confrontation. As the sun dipped and the lake returned to quiet, I stood at the shoreline looking out over water that had become a battleground without ever changing shape, realizing how quickly peace can be disrupted when authority is abused, and how dangerous it becomes when lies are enforced through pressure instead of proof. The crisis wasn't that the HOA had been challenged. It was that it had chosen to involve law enforcement to legitimize a false claim, and once that line is crossed, consequences stop being hypothetical. I knew the HOA president believed the call would scare me into compliance, that the presence of uniforms would shift the balance in his favor, but the opposite had happened, because now there were official records, reports, and witnesses documenting exactly who said what and why, and those records don't disappear. As nightfall approached and the road grew quiet again, I understood that the crisis had clarified everything, the lie was exposed. But exposure alone doesn't end power grabs, accountability does, and the next phase wouldn't be about signs or emails or crowds by the water. It would be about financial, legal, and structural consequences that an HOA can't talk its way out of once the truth is fixed in writing. And at that moment, standing alone by my lake again. I knew the call they had made in confidence was the same call that would ultimately cost them everything. The turning point didn't come with another argument at the lake or another crowd gathering on the road. It came quietly through paperwork, deadlines, and a shift in tone that the Homeowner Association clearly wasn't prepared for. Because once the police report was filed and the incident was documented, the lie stopped being just a rumor and started becoming a liability. Within days, formal inquiries began, not from residents, but from agencies that don't care about community politics or feelings, only about records, authority, and responsibility, and that was where everything started to unravel for the HOA. I was contacted and asked to submit documentation verifying ownership of the lake, something I'd already organized down to the smallest detail: the deed, the recorded survey, tax assessments, aerial imagery, historical filings, and correspondence from the HOA itself claiming ownership. And when those materials were reviewed side by side, the contrast was devastating, because my claim was grounded in public record while theirs existed only in emails, signs, and verbal assertions. The HOA president attempted to get ahead of the situation by sending out another community-wide message, walking back previous statements, claiming the lake's status had been miscommunicated, and suggesting that access was never meant to be permanent. But the problem with written lies is that they don't disappear just because the tone changes, and multiple residents had already forwarded earlier emails directly to investigators. As the review progressed, it became clear that the HOA hadn't just misunderstood ownership. It had actively represented the lake as community property without any legal basis, encouraged residents to enter private land, installed signage, scheduled maintenance, and escalated the situation to law enforcement, all actions that compound liability when done without authority. The turning point solidified when the HOA was formally notified that its actions were under investigation, and that notification carried weight because it outlined potential violations, misrepresentation, trespass facilitation, and exposure to civil damages, language that doesn't get used lightly. Emergency board meetings were suddenly scheduled, not advertised, not open, held behind closed doors as leadership scrambled to control fallout, and the confidence that had fueled the original claim evaporated almost overnight. Residents noticed the shift immediately because the same association that had spoken so boldly about community ownership was now cautious, vague, careful with words, and that alone told everyone something serious was happening. I was asked to attend a formal mediation session, not as a courtesy but as part of the investigative process. And when the HOA president finally sat across from me in a neutral setting, his posture was different, quieter, defensive rather than aggressive. Because the conversation was no longer about what he wanted the community to believe, it was about what could be proven. When asked to produce the document granting the HOA ownership or access rights to the lake, he couldn't. And when pressed about the source of the claim, he admitted it was based on assumptions tied to developer conversations that were never recorded, never filed, and never enforceable. An admission that mattered more than any argument we'd had at the water's edge. The turning point reached its peak when investigators made it clear that intent, belief, and tradition don't override recorded ownership, and that representing private property as communal without legal authority exposes an organization to significant damages, especially when that representation leads to trespass, confrontation, and police involvement. From that moment on, the question stopped being whether the HOA was wrong and became how much that wrong was going to cost them. Notices went out instructing the HOA to immediately cease any representation of the lake as a community amenity, remove all signage, halt communications claiming access, and issue a written correction to residents acknowledging the lake was privately owned. And watching that correction arrive in inboxes felt surreal because it directly contradicted days of confident declarations. The association complied quickly, not because it wanted to, but because it had to, and the lake returned to quiet almost immediately. No more visitors, no more signs, no more foot traffic, just water and wind and the sound of things going back to the way they were supposed to be. But the turning point wasn't just about restoring peace. It was about momentum, because once the HOA acknowledged in writing that it had misrepresented ownership, it lost the ability to frame the situation as a misunderstanding, and every previous action was now viewed through the lens of responsibility rather than confusion. As the days passed and the investigation continued, it became clear that the conflict had moved permanently out of the HOA's control, because organizations can survive embarrassment, but they struggle to survive documented misconduct tied to financial exposure. Standing by the lake again under open daylight, watching the water settle back into stillness, I understood that the moment the HOA involved authorities to enforce a lie, it set in motion a process that couldn't be stopped by apologies or retractions. And whatever the outcome was going to be, it would be decided by law, numbers, and consequences, not meetings or messaging, and that realization marked the true turning point. The moment when the balance of power shifted for good and the HOA's claim collapsed under the weight of reality. The resolution came down not in a single dramatic moment, but in a sequence of consequences that stacked up so quickly the homeowner association barely had time to react before everything collapsed. Because once the investigation concluded, the findings were precise, unforgiving, and backed by numbers. The final report confirmed that the HOA had knowingly misrepresented private property as a community amenity, encouraged repeated trespass, installed signage without authority, escalated the conflict to law enforcement under false pretenses, and continued pushing the claim even after being presented with clear proof of ownership, and each of those actions carried its own liability. What turned the situation irreversible was the financial exposure, because multiple residents who had been misled filed complaints of their own, stating they had been encouraged to use the lake, told it was theirs, and then placed into a hostile confrontation as a result of the HOA's actions, and that expanded the scope from a single dispute into organizational misconduct. Insurance carriers became involved next, reviewing whether the HOA's policy even covered intentional misrepresentation, and when that question was raised, coverage was suspended pending review, a move that sent shockwaves through the board because it meant any damages would come directly out of association funds. Emergency meetings followed, frantic and disorganized, as board members realized the situation was no longer about pride or control. It was about survival, and in those meetings, the president's actions were no longer defended, they were dissected. The financial assessment that followed was brutal: legal costs, regulatory penalties, settlement obligations, and restitution combined into a figure that surpassed anything the HOA had budgeted for. And when the final number was presented, it was clear the lie had become catastrophic. The board voted unanimously to remove the president, effective immediately, citing reckless escalation, abuse of authority, and exposing the association to severe financial harm. And this time there was no hesitation, no debate, because everyone understood what had to be done. A settlement agreement was reached soon after, formally acknowledging the lake as private property, prohibiting the HOA from any future claim or representation regarding it, and compensating for damages caused by trespass, enforcement abuse, and reputational harm. And when all costs were accounted for, including legal fees and penalties, the total impact exceeded $1.2 million, a number that stunned residents who had once believed the lake was a harmless perk. Notices went out to the community explaining the outcome, carefully worded but unmistakable, clarifying that the lake had never been community property, that previous communications were incorrect, and that the association had suffered significant financial loss as a result of leadership misconduct. And reading that message felt surreal because it stood in direct opposition to the confidence with which the HOA had made its original claim. The lake returned to silence completely. No signs, no visitors, no rumors, just water and shoreline under open daylight, exactly as it had been before the lie began, and the difference now was understanding. Because neighbors who once accepted HOA declarations without question now read every notice carefully, aware of how easily authority can be abused when it isn't challenged. State oversight remained in place long enough to mandate governance reforms, training requirements, and strict limits on how the HOA could communicate ownership claims going forward. Changes that reshaped the organization into something far more cautious and far less aggressive. And that transformation wasn't optional, it was imposed. The former president disappeared from community life entirely. No appearances, no explanations, no attempts at redemption, just absence, the quiet end of a man who had believed confidence could substitute for truth. Standing by the lake again under the same bright daylight, I felt something deeper than relief. Because the outcome wasn't just personal vindication, it was structural correction, proof that when an organization builds authority on lies and tries to enforce them through pressure and intimidation, the collapse isn't just embarrassing, it's expensive. The story didn't end with shouting or triumph. It ended with accountability measured in documents, rulings, and dollars. And the lesson spread quickly through the community and beyond, because people talk when an HOA oversteps and pays the price. The lake remained exactly where it had always been, unchanged and unmoved, and that felt fitting because land doesn't bend to narratives, it answers only to law, and once that law is enforced, everything else falls back into place, leaving behind a quiet truth the Homeowner Association learned too late, that claiming what you don't own doesn't just cost credibility, it can cost everything.